everyone for being here. It's really with great pleasure that I introduce to you Vic Sher, which is a different name than my husband's last name, Sher. It's actually the same name pronounced differently. They're cousins. Vic has had and continues to have an extraordinary career. Over 30 years of experience focusing on developing legal strategies that protect both the planet and the people who live on it. He's led the world's largest public interest environmental law firm. We've got a rock star amongst lawyers here with us today. He's gone toe-to-toe, and I will add successfully, with some of the world's most powerful polluters and largest law firms. He's done extensive work on public water supplies, for example, MTBE and groundwater, which I know Vic is going to speak about today, and worked with Earth Justice, formerly the Sierra Club Legal Defense Fund, for the especially noteworthy case of the spotted owl, which I'm sure many of you are familiar with. I just want to read a little quote by Law Dragon. Many lawyers enter the legal profession to quote-unquote make a difference, but few lawyers have had such a massive impact through litigation, particularly in the area of environmental law. And if you don't think this guy is a total rock star in the world of environmental law, you should ask him about his guitar playing. With that, I'm going to hand it over to you. Vic is going to speak, and we'll leave some time for Q&A at the end. Thank you, everyone, for coming.
Thanks, Laura. I will add that Rogers and my father were brothers, and I'm the elder. My father was the elder brother of the two, and our pronunciation of the name is actually the correct one.
It's a West Coast accent.
It is. How many of you are scientists? And how many of you have ever testified in court? The work that is going on here at the University of Maine on the relationship between science and policy and action, I think, is extraordinarily important. And I want to try and do two things today. I want to talk with some specificity about how I prepare my experts for testifying in the courtroom. And I also want to talk about the perception that science either is misused or abused in the courtroom. And I was thinking as I was coming out here, in 1995, I was invited by the American Bar Association to address the Bar Association section on natural resources, environment, and law. I'm missing a word in there somewhere. It's called Sonreal. And in Scottsdale, Arizona. And I had an audience which was about 350 lawyers for the timber, mining, and grazing industries. In 1995, I was coming out of a period of litigating spotted owl cases for Earth Justice. And President Clinton at the time was on the verge of signing the most anti-environmental piece of legislation ever. It was a law that was attached to the compensation for the Oklahoma City bombing victims that literally suspended all of the federal environmental laws on federal public lands. And my presentation to this group of lawyers was, I thought, a very restrained and rational one. And I talked in it about some of the spotted owl cases, but also about how the pendulum of public opinion and public will swings back and forth, and that they were probably feeling pretty good at this moment, but that the pendulum, if they weren't careful and if they weren't a little bit restrained, the pendulum would swing back and they would find themselves off of the public lands. And I sat down to tepid applause. And it was a point-counterpoint presentation, and the counterpoint came from a lawyer, a natural resource lawyer from Oregon named Jay Waldron. And Jay started off, he came to the podium and he said, first of all, let me say that it is an honor and a privilege to share this stage with an experienced and eminent litigator like Mr. Sher. But I'm here to tell you that everything he has just told you are lies. And he has single-handedly perpetrated the biggest scientific and legal fraud on the federal courts ever. And he went on to argue that our science had been junk science, that the federal judges had improperly stepped in and started to manage the public lands, and that this was a travesty that should never be allowed to be repeated. He sat down to thunderous applause. And the moderator passed the microphone back over to me and said, "Vic, would you like a few moments to respond?" And without thinking about it, I grabbed the mic and I said, "You know, the only thing that comes to mind is the old Saturday Night Live line, 'Jay, you ignorant slut.'" And there was dead silence, and I thought, oh no, I've really stepped in it. And then the room erupted in laughter, and I went on to give my counterpoint. Well, it turned out that this theme of junk science and abuse of judicial process was one that was not unique to that presentation. A few months later, I followed Orrin Hatch, that friend of the environment, in a presentation in D.C., and he made almost the same words, the same claim that the spotted owl cases had been a travesty of both law and science. Fast forward years later, I leave the nonprofit world. I'm in private practice representing cities and counties and water utilities and states against the oil industry over groundwater contamination from the gasoline additive MTBE. And the Associate General Counsel for Lyondell Chemical Worldwide, which was the world's largest producer of MTBE, was on a panel and published a series of articles in which he claimed that our MTBE cases represent, quote, "a new tyranny that is growing in the United States, the ultimate goal of which is not the general public interest, but rather profits derived from exploiting public fear, media hype, political influence, junk science, and the complexities and financial burdens of litigation." And this is a theme, as I was thinking about things, that is not unique to my cases. It is one that we see on everything from tobacco and secondhand smoke to the hole in the ozone layer to climate change. And as I hope to address it in the context of the spotted owl and MTBE cases, but let me give you a couple of my biases going in, which probably won't surprise you. I believe that there is good and evil, and that there is good science and bad science. And the truth of the matter is that the courts, in almost every environmental issue that you can think of, going back 50 or 60 years, have played a significant role, frequently a one that is very important on the good science side of things. And the claim that the courts have been abused and that bad science have been used is part of a claim by affected economic major interests to try and deflect the impact of the role that the courts and science have played. And it's wrong. The courts are frequently the only level playing field for victims of both governmental and corporate malfeasance. But first what I want to do is give you a flavor for how I prepare experts as a sort of a context for my later comments. Rule number one. This is what I tell every scientist who comes in who is preparing to testify in my cases. Always tell the truth. Now this has a benefit, of course, many benefits, but one of the benefits is when they're asked, "What did Mr. Sher tell you?" they can respond, "The first thing he told me was always tell the truth." But I mean this more than sort of the hand on the Bible swearing the court oath. Cases that are brought that matter depend on the credibility of the science and frankly the lawyers. And when you get in front of either a judge, but more importantly in front of a jury, if the jury believes that the scientific testimony has been weighted, They see it as an effort to mislead them in their job of trying to find the facts of the matter. It is poor advocacy, and it doesn't work. And I will tell you, as one who is not a scientist but who cross-examines them in courtrooms, that working with good scientists on my side, if an opposing expert has his or her thumb on the scales, I'll find it out and I'll expose it. So the other part of this is that expertise and credibility and qualifications matter. I make every effort in my cases to find the leading experts on a subject and to then allow them the opportunity to tell the story. They get attacked on a variety of personal and professional and scientific levels, both in the courtroom and outside of the courtroom, as they have been regardless of the court cases. Their strongest defense is their expertise and their ability to respond credibly to criticism, scientific and otherwise. And actually the courtroom is an excellent opportunity for them to do that. By the way, in my experience, the other side frequently does not share the same concern about the truth and credibility. Now, part of the context here is who is an expert? And scientists view the answer to this question differently than the way the law views the answer. This is the Federal Rule of Evidence 702, which is the framework for presenting expert testimony in federal courts. And it says that a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion, which is what experts do, if the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. Now, this basically means that if the expert has knowledge beyond what the ordinary juror would have, then they're qualified to testify as an expert. Most scientists view expert in terms of their own area of expertise and will be generally self-deprecating if asked if they're an expert in another field. And a prime example of this is we worked on the MTBE cases with a hydrogeologist, a professor of hydrogeology from the University of California, Davis, named Graham Fogg, who is a leader in his field. And he was at one point asked in his question, well, do you consider yourself an expert in statistics? And if he had not been prepared, his answer would have been no, because that is not his primary focus. Well, it turns out that not only does he need to understand statistics sufficiently to deal with his modeling results and all that kind of stuff, but he teaches a course at the graduate level in the use of statistics in hydrogeology. So even though it's not a primary area of research or expertise for him, certainly in terms of the federal rules of evidence and his ability to testify, he qualifies as an expert. The other three categories here have to do with the sufficiency of facts or data, the product of reliable principles and methods, and the reliable application of those reliable methods to the data and the facts. And the other side will try to knock an expert out, that is, not even allow the testimony to go to a jury on the basis that it doesn't, that his or her testimony doesn't satisfy these criteria. They'll say either they're not an expert in an area or that they have not used reliable, sufficient facts or data or reliable principles of methods. And that's where most of the pretrial fighting goes into. And an expert who isn't thoroughly prepared to defend this can be really vulnerable to being thrown out. It really matters who your expert is, and the credibility, as I mentioned, is tantamount. And let me just give you one brief example from a case that I was not involved in, but I was reading this case recently. It involves a challenge by a citizens group to the failure of the Texas Water Board to regulate water flows that were affecting whooping crane habitat. And when the judge issued his opinion in the case, he said that the plaintiff's experts, quote, were world-renowned in their respective fields. Several of their witnesses hold endowed chairs at prestigious universities. Some are MacArthur Fellows, Genius Grant recipients. All have published numerous scientific papers in respected journals. Indeed, one witness is a shared recipient of the 2007 Nobel Peace Prize for his work. He said the other side's people did not have the same eminent qualifications, had not done any work on cranes, and by the way, had obviously manipulated the data. In fact, there was one cross-examination. The judge said that this witness had testified. The issue was salinity in the marshes and their impact on the whooping cranes. And this one guy had testified that the cranes had a highly developed gland that allowed them to absorb salt water without harm. And when the judge asked him where he had gotten that opinion, eventually the guy admitted he just made it up. So what you never want to have is you may think that that's an extreme example. In my experience, it happens far more frequently than you would expect. It's usually clothed a little more subtly, but the I made it up response is not all that uncommon, unfortunately. All right, some other tricky questions that scientists run into that need to be understood. First of all, the opposing counsel puffs themselves up and says, Dr. So-and-so, is your opinion, do you hold your opinion to a reasonable degree of scientific certainty? Now, scientists, when they hear reasonable degree of certainty, usually think in terms of confidence levels and intervals. And frequently, the work on which, or the opinion that they're expressing, it has not been developed to that degree of technical rigor. But this is a trick question. What it really means is a combination of, going back to the standard, have you used reliable and reasonable methodologies, and is your conclusion more likely than not? A scientist who doesn't understand the question as posed in this pompous Perry Mason sounding language can get knocked out when in fact they have used reliable methodologies and sufficient evidence and all the rest. The second issue that comes up has to do with innovation and novelty, and this is really a tricky one because scientists, I think, like most people, like to take credit for original thinking. And so frequently the question will be framed in terms of, are you the first to develop this approach? This is really great, so you think your approach is better than the way other people do it, and it's novel, and that kind of stuff. And there is now a line of cases inspired by the U.S. Supreme Court on novelty and reliability that's known as the Daubert case. Some of you may have heard of this. And it tries to flesh out the standards. And there's a whole body of case law that develops at the edges. The truth is, an expert is allowed to testify to novel opinions if they have been subjected to the equivalent of peer review and if they've gone through various other criteria for reliability. As a practical matter, novelty and innovation, I think, are anathema. And my experts always respond, I have applied. Even if the work is a new application of old methodologies, I have applied down the middle of the runway science here. This is not new. It's, even if the results are new, it is the application of well-established approaches. It has to do with it being the best science. Use of models comes up a lot in almost every technical or scientific case. And But by the way, these these points are born out of sometimes painful early experience. So I literally had an expert who was really great, who was pushed on the use of models and the role of uncertainty, and how the models are representations and aren't the real world, and there are always things you can't do it. And the other lawyer looked at him at one point, and I was younger then, and I had let the conversation get a little too conversational, and my guy was a little bit careless, and the lawyer said, so what you're really saying is that models are really just educated guesses? And he said, yes. And I took him out into the hall, and I threw him up against the wall, and I said, you're going to go back in, and you are going to change it. It's not guesses. It's the best use of information. It's used all the time. We can't perfectly replicate the real world, but models are our best tools, and you use the best information to use the best models. So, but that's a tricky one. Hypothetical questions. This is the nature of what experts are asked to do, and frequently, and it's proper to ask hypothetical questions. What the expert has to understand is that he or she really understands all of the variables and all of the inputs that go into the hypothetical. So the first response to any hypothetical question by an expert should be, you mean all other things being equal? So that there are no hidden assumptions that may change the outcomes. That's the most important thing. Repetitive questions. Lawyers will ask scientists, especially in pretrial proceedings, the same questions, just with slight variations over and over and over and over again. And it works. They get tired and they get careless and they give different answers. And then those different answers are used to show that the scientist is inconsistent or careless. The way you handle this is you say, I've already answered that question. By the way, on Perry Mason, you'll see the lawyer saying, asked and answered. Well, that's not actually an objection. And it can't prevent the witness from answering. The proper objection at a certain point is burdensome and harassing because of the repetition, but again, that doesn't stop the lawyer from being entitled to it. So the way to put an end to it is for the scientist to look at the lawyer and say, I've already answered that question. I have nothing to add to my previous answers. And I usually suggest that they let like 2 or 3 iterations of the question go by. The other thing to do is to say, I don't understand how your question is different from the earlier question, so that if there is a difference, the scientist can figure that out and then answer appropriately. All right, a few other very quick things that scientists need to understand when they're approaching the courtroom. The first is that the judge plays 2 different roles in a courtroom. The judge can act as a gatekeeper to disallow the testimony altogether. That is, normally the jury is what's charged with uncovering the facts of the matter, and the judge is just supposed to handle the law. But the judge can act as a gatekeeper to disallow the testimony from even reaching the jury in the first place. And so you have to, when you talk to the judge in that pretrial context, you have to communicate effectively with the judge so that he or she understands how the science is being appropriately done with reliable methodologies and sufficient evidence to act on. The judge, in some cases, can also act as the fact finder in cases in which there's no jury. So, and that's the judges then as a different audience for the scientific opinions. If the jury is the trier of fact, then the witness needs to know how to talk to a jury. And this is an error of arrogance that scientists, and especially, forgive me, David, but academics can make, is to think that because they know how to do science, and because they know how to deliver a lecture to a group of graduate students, or even undergrads, that they therefore know how to talk to a jury. Because they don't. Now, some people are naturally very good at talking to juries. Others have to learn how to do it. And scientists who are looking at going into the courtroom should understand that they're going to need to be prepped. And and they're going to need to work with lawyers and consultants. I usually put, in important cases, big cases, I put the scientists through video training. And we had one case in particular comes to mind. We had a woman testifying as to engineering costs for building a treatment facility for water treatment. And she was delightful. She was very, very smart. She had written an extraordinary report that analyzed all the factors. And on the stand, when we mocked her, not when we made fun of her, but when we ran her through a mock proceeding, she was too deferential. And so she had a very sort of diminutive mannerisms, and also too quick to concede points, frankly. And so we showed her where that behavior, first of all, we showed her what it looked like, but then we showed her where that behavior could lead in terms of opening a door for certain very aggressive lines of cross-examination. She cried. And then she was a star at the trial. The jury loved her, and she did phenomenally. So understanding that this is a skill that needs to be learned is an important point, I think. And this is related to developing and delivering the story. One of the things that I don't enjoy the most is tussling with a scientist over what they think is important as opposed to what is really important for our case. So that needs to be worked on as well. Now, dealing with cross-examination. There's a saying in law school that if the facts are against you, argue the law. If the law is against you, argue the facts. If the facts and the law are against you, pound the table. If you have a strong, credible witness who the other side knows is going to appear well to the jury and make a good impression, they will pound the table. And what the scientist has to understand is that that's part of the process. And frankly, usually it doesn't work. It's unpleasant, but it doesn't work. And I remember in one of the trials in Portland, Oregon, over the spotted owl, a very eminent population dynamicist took the stand to testify and gave, this was to a judge, not to a jury, and he gave really beautiful direct testimony in response to my questioning. Timber industry lawyer stood up, and his first question, I kid you not, was, are you now or have you ever been a member of the Audubon Society? Thinking that that was somehow going to shade the responses. This is Barry Noon. He is not the population dynamicist I just mentioned, but he is a population dynamicist, very, very brilliant one. He did the modeling work on the Forest Service plan for the spotted owl that was the first to actually address population dynamics. And there was I'll let him tell the story. This should be, it's not showing it loading. Uh-oh.
We'll go get Carol.
Well, we're going to run short on time, so let me just tell you what he's doing. This is from a movie called The God Squad in the Northern Spotted, the Case of the Northern Spotted Owl, done by Emily Hart, which is a marvelous movie. And Barry is telling the story of the God Squad is the cabinet level, federal government cabinet level committee, which has the authority to exempt species from the Endangered Species Act after the Fish and Wildlife Service has determined that federal action is likely to jeopardize their survival. And one of the pieces of the spotted owl story was that the Bureau of Land Management wanted to sell some timber sales on Bureau of Land Management land, and the Fish and Wildlife Service said that'll jeopardize it, and so BLM went up and escalated it. We got to spend 2 months in Portland having a big trial. And after he had been testifying for a while at this, the timber industry lawyer asked him to perform a variety of very complicated algebra problems. And Barry says, you know, they had marginal, if any, relationship to his testimony and the modeling work that he'd done. And it was clear that the purpose of the question was to try to trip him up and embarrass him, creating the implication that if he would make mistakes doing algebra, how could his model be appropriate and correct? And he put up with it for a little while, and then he sat there in this proceeding and said, "I'm not going to do this anymore. This is not how I do science, and I'm just not going to do it anymore." Now, if he had actually been in a courtroom, there was a good chance that the judge would have ordered him to do it once or twice, and then told the other lawyers to move on. But it was an eloquent and powerful moment. So let me now turn to the spotted owl cases, line of cases, and the MTBE cases. These cases are case studies, and I think they're important. I mean, even though the spotted owl cases are now 20 plus years old, they're important because there was so much controversy that was going on. There were so many court cases. Science played such an important role. This is true for both MTBE and spotted owl cases. And they are really major intersections of law, science, and public policy. And the charge that science was misused or abused in the courtroom is a very powerful one that has gained some traction in both the academic press and the popular eye. And the spotted owl cases affected tens of millions of acres of federal public lands, literally led to a revolution in federal lands management policy, introducing ecosystem and biodiversity concerns rather than just maximizing resource extraction. And MTBE litigation literally led to the removal of one of the most ubiquitous chemicals in gasoline, MTBE, which was an enormous profit center for the oil companies, and they fought it very hard. Both lines of cases involved multiple courthouses around the country, huge corporate interests on the other side, battles in Congress and in the court of public opinion, and in both good science and good law prevailed, and in both the losing corporate interests accused us of perverting both science and the courts. So, was science abused in the northern spotted owl controversy? Yes, it was. But that abuse occurred in the federal agencies and in the Congress, and this is demonstrably true. Government agency scientists testifying in court told us repeatedly that their work had been distorted for political reasons. And in addition, Congress passed a series of laws targeting our lawsuits that closed the courthouse doors to us for a number of years. So our claims that were based on best science didn't get a forum, and they were kept out of the courts for many years. Did science suffer similar abuse in the courts when we were finally allowed to litigate the merits of the cases? No, it didn't. Indeed, the courts emerged as the one forum in which efforts to abuse science failed. Now, you have to understand that the controversy over the spotted owl had its genesis in a major paradigm shift in how tens of millions of public acres needed to be managed to preserve the species. In the early 80s and before that, the Forest Service and BLM had adopted management plans that preserved 500 pairs of owls, each of which had a certain minimum of acreage of around 1,000 acres on which the pairs could survive. And so the first question was, how do you frame the science and get it into the field? And when I joined Earth Justice, we hired a young forester, then young forester named Andy Stahl, who asked the question, first of all, where did the 500 pair number come from? And the Forest Service told him that it had come from a personal communication with a population expert named Michael Soule, and who is actually one of the fathers of population analysis. And Andy called up Soule, and Soule told him that he'd never said that 500 pairs would be a viable population. Rather, what he had said was that there were some experiments in bacteria that talked about how 500 pairs of an organism was the minimum that you needed in order to avoid genetic deterioration through mutations and inbreeding and stuff like that. And Soule told Andy, I don't really think that kind of genetic degradation is the biggest threat facing the owl, and suggested that he find somebody who analyzed population dynamics. So Andy went out and tracked down a guy named Russell Landy, who was a population mathematician and modeler, and actually ran him to ground in Maine, and over a lobster dinner posed the question to him. And Russ said, if we think of this question in terms of comparing the rate of local extinction, that is how quickly individual owl pairs die out, compared to the rate of recolonization of available habitat across the landscape, it's only if the rate of local extinction is less than the rate of recolonization that you have viability. Otherwise, you have a slide down to extinction. And he said, by the way, my initial analysis looks like, and he developed the idea of an extinction threshold, and published a series of peer review articles starting in 1987, in which he concluded that the government's plan was likely to cause the extinction of the owl because suitable habitat in the region will be too sparsely distributed to support a population. So Andy then took his articles, peer-reviewed, and gaining traction in the scientific community, and he went to the Forest Service and the Bureau of Land Management, and he said, okay, change your plans. And they said no. So he came to me, and he said, so let's sue. And I said, not so fast, grasshopper. I mean, you have to understand that suing the government is like fighting with both legs and both hands tied behind your back with a blindfold. Separation of powers vests the discretion for managing public lands and other governmental mandates in the federal agencies. And the only role that the courts can play is to say proper procedures haven't been followed, or that there has been no explanation provided for the relationship between the information on the one hand and the decision reached on the other hand. So I said, look, the hard reality is this. If you have 100 experts, all equally qualified, 99 of them say X, and the 100th says not X, you'll lose a lawsuit. The government is entitled to make those choices, not the courts. You'll lose in court every time. He said, well, I think we have a pretty strong consensus on the owl. I said, really? And so the first step was trying to get the owl listed under the Endangered Species Act by the Fish and Wildlife Service. And so there was a petition to the Fish and Wildlife Service. The Fish and Wildlife Service said, no, we're not going to list it. And they cited a guy named Mark Boyce. And once again, Andy called up Boyce, and Boyce said, gosh, I never said that the owl didn't warrant listing, and I would feel terrible if anything that I said or did harmed efforts to protect the species. And when we went to court, the judge said we had the Fish and Wildlife Service's own population expert, Mark Schaefer, had written a report saying that the owl warranted listing, and there was no explanation. So the owl eventually got on to the Endangered Species Act list. Then we went to the Forest Service and the BLM and said, update your plans so that you actually maintain a viable population and that you take into account this new information. And they refused. So we went to court. Remember, in court, the issue is never what's the best or wisest way to act. It's only has the discretion properly vested in the agencies been abused. And in case after case, what we found was testimony like the following. Eric Forsman, who was one of the leading government owl biologists, testified that starting in the mid-1970s, spotted owl management plans on federal lands had been subject to, quote, a considerable, I emphasize considerable, amount of political pressure to create a plan which had a very low probability of success of preserving the owl, but which had a minimum impact on timber harvest. It's hard to imagine a more direct acknowledgement of political interference in science. Remember, this is not the courts. This is testimony about what happened in the government agencies. In October 1987, we filed suit in federal court in Oregon seeking to compel the BLM to address the new information about the owl and update its environmental impact statements. And Congress responded by passing between 1987 and 1991 a series of bills attached as part of appropriations laws that disallowed our challenges and stated literally, quote, there shall be no challenges to any existing plan of the BLM or the Forest Service solely on the basis that the plan does not incorporate information available subsequent to the completion of the existing plan. Abuse of science in the courts? No, it was in the Congress. This political maneuver by Congress kept our lawsuits against the BLM and the Forest Service, which we ultimately won big time in 1991 and 1992, out of court until then. So, as the court found in one of our cases, quote, more is involved here than a simple failure by an agency to comply with its governing statute. The most recent violation exemplifies a deliberate and systematic refusal by the Forest Service and the Fish and Wildlife Service and the BLM to comply with the laws protecting wildlife. This is not the doing of the scientists, foresters, rangers, and others at the working levels of these agencies. It reflects decisions made by higher authorities in the executive branches of government. Now, we'd won these cases. We had gotten the courts to declare that the conduct was illegal. Did that mean that the logging stopped? No. The court still had to then find whether, in all fairness, it should allow timber sales to go forward despite the legal violation. By now, Jack Ward Thomas had developed what was called the Interagency Scientific Committee plan to preserve the spotted owl, and they said, we'll go forward in a manner, this was wonderful language, not inconsistent with the Interagency Committee plan, and it had reduced, the ISC plan would have reduced the timber logging from about 500 million acres per year down to about 66,000. So it was a substantial 80 or 90% reduction. And they said, let us go forward. And so we had this big hearing, a 10-day hearing in Seattle in front of one of the judges, and economists testified, and the timber industry economists said, you're going to destroy the remaining timber industry jobs, and Western civilization as we know it is going to end. Seriously, this is his testimony. And for the first time, we as the environmental community were able to take on the economics and presented testimony that said that the changes in the timber industry were independent of the spotted owl, that the industry had lost over the previous decade something like 30,000 jobs at a time when Oregon and Washington's economies had been adding hundreds of thousands of jobs. And so the judge went through and found ultimately there was a risk of extinction to the owl on which scientists disagreed, and that he wasn't going to make the call on that. But that the mightiest economy on Earth could wait until there was an environmental impact statement that followed the law that came out, and he issued the injunction. So here's my takeaway that I want you to take on this. Despite the institutional limits on the proper role of courts, and that they're not federal land managers. In the spotted owl controversy, the courts were literally the only forum in which good science actually got aired. And the courts did not make management decisions for did not replace federal agencies' discretion. Rather, what they did was they forced the agencies to comply with the laws, which are public disclosure and debate laws and good process. And as a result of it, the government finally developed a spotted owl management plan that reflected current thinking and survived public review. Those cases were a heck of a ride for me. I mean, as a litigator, I got to be involved in what was a very important, prominent, and exciting issue. And I'm a little bit of a media hound, and I enjoyed all of that. But I have to tell you that these lawsuits should have been unnecessary. The legal obligations weren't new. The scientific issues were new and emerging, but they weren't. You know, the failure was the absence of consideration of them, and they involved clear, well-established obligations under existing laws that the agencies understood but chose to ignore. And I believe that both the public and the environment would have been better served if the government had simply obeyed the law from the outset. Now, let me fast forward in my career to MTBE, stands for methyl tertiary butyl ether. I will zoom through this because I want to make sure that there's time for some questions. And many of the points are very similar, although the legal context was very different. We obtained in pretrial proceedings, we got a memo that had been written by one of the Shell scientists who dealt with MTBE, and he said, MTBE, yeah, it stands for methyl tertiary butyl ether, but it also stands for most things biodegrade easier and major threat to better earnings, some other things. So here was the crux of the MTBE claim. It was that MTBE.
It's Shell.
They're everywhere. They're everywhere. I'm so sorry.
It was great comic relief.
So here's what our case boiled down to is that MTBE, when you added it to gasoline, made gasoline that leaked from underground storage tanks a radically different threat than gasoline that did not contain MTBE. And the reason was that its fate and transport characteristics in the subsurface are completely different. In shorthand, it travels farther and faster and doesn't biodegrade. And this means that it has a higher chance of reaching both private and public wells, and it's very expensive to remove from the water once it gets there. Oh, and by the way, the companies knew about it, didn't warn anybody about it. So the innovation in the lawsuit was viewing this groundwater contamination, drinking water pollution problem as the responsibility of the refineries who had made the decision to add MTBE to the gasoline, rather than as the cleanup responsibility of the local gas stations, which is the way most contamination problems have been dealt with for decades, and it's the way Superfund deals with it, and the way RCRA deals with it, and so we said, that won't work for a variety of reasons, not the least of which is it can cost tens of millions of dollars to clean up a contaminated public drinking water well, and Joe's Corner gas station is a marginal business that can't possibly pay that. And by the way, they were just handling the gasoline the way they'd always handled gasoline and weren't culpable. So we developed some visuals. This first one is from a well-studied site in Southern California called Port Hueneme. Gas station is down here in the lower right-hand corner. And that is the BTEX, the non-MTBE portion of the plume. It's about 1,200 feet long. Still significant. But here's the MTBE plume. Okay? And in general terms, the BTEX components, that's benzene, toluene, ethylbenzene, and xylene, toxic, no question. But they're fossil fuel elements, And over time, these plumes stabilize and biodegrade, even if you do nothing, in most environments. MTBE, artificial compound, and basically doesn't biodegrade, so it's there for good. So that was California. We had a case. I represented the city of New York against Exxon for MTBE contamination in Queens. We said, well, okay, that's California. What about New York? Well, New York has sandy soils, a lot like the Port Hueneme site. Here is one in Deer Park, New York. There's the gas station in the upper right. Here's your BTEX plume. It's long. It's a 1,000-foot plume. Here's your MTBE plume. 1.5 miles long. These are, by the way, a picture's worth 1,000 words. Okay? So then we get to New Hampshire, state of New Hampshire suing the oil industry. They have fractured bedrock. And one of the contentions by the oil industry scientists was, well, that's completely different from the sandy soils in California and in New York, so we're not, we're going to object to any of these visuals going to the jury because it's not representative. So here we have a leak, lower left here. Here's the BTEX plume. There's the MTBE plume. And by the way, where are they? There are all the receptor wells in the neighborhood there. So the unpredictability of the fractured bedrock, contrary to what the industry was saying, actually made the situation worse from a water contamination perspective because the flow was completely unpredictable. And if you didn't have a terrific monitoring well network, you would never get it. So we were aided in this by internal memos from Exxon in particular. This is from 1984, subject use of MTBE in Exxon motor gasoline. We have ethical and environmental concerns that are not too well defined at this point. For example, possible leakage of storage system tanks into underground water systems of a gasoline compound that is soluble in water to a much greater extent. This is a memo from an Exxon scientist the following year saying, as stated in our previous memos, MTBE in Exxon gasoline is of concern as an incremental environmental risk for 4 reasons. It travels farther and faster, it doesn't biodegrade, it's expensive to remove, and I can't think of what the 4th one is right now. Oh, very low taste and odor thresholds. So it may not be detected, or will be detected. People will smell it and taste it. As a result, we recommend that from an environmental risk point of view, MTBE not be considered as an additive to Exxon gasolines on a blanket basis throughout the United States. Well, Exxon went ahead and added it and didn't bother to tell anybody what it knew about it. And in 1990, when Congress amended the Clean Air Act amendments to require higher oxygen content, MTBE production, use, and sales just went through the roof. It was basically in every gallon of gasoline sold on the coast. In the interior, they used ethanol instead. Now, when we built our case, this guy was an Exxon executive, and I asked him, would you agree that if a company knows the dangers of its products, it has a duty to warn? Yes. Would you agree that a company that has the duty to warn, that the warning goes to those who handle and use the product, like the gasoline station owners? Yes. And he answered yes. And then Exxon conceded that they had known, as they had to, that they had known of the dangers that its own scientists had told them about. And then I said, and your company provided no warnings to anybody about increased risks of contamination, greater costs in connection with MTBE and gasoline, correct? And he answered, correct. He really had no, I mean, their whole theme of the case was, well, first of all, they claimed that MTBE actually now does biodegrade, and which it does a little bit in laboratories if you add tons of oxygen to it. But they hadn't warned anybody. They said, well, gasoline's not supposed to leak out of gas tanks anyway, and there are laws against spilling and leaking gasoline, so why is MTBE any different? This guy was great. He was the executive who approved in 1985 the use of MTBE in Exxon gasoline. We asked him about whether he knew that it would go to mom and pop stations as well as Exxon branded stations, and asked him, You made no effort even to inform station owners that MTB was in the gas. He says, we didn't uninform them. So the response was, after the first set of lawsuits, which we won a lawsuit in California for the South Tahoe Public Utility District, was that the oil industry went to Congress and tried to get immunized. And we came literally within a single vote in the Senate in 2005 of being thrown out of court on this. This was the proposed language. Notwithstanding any other provision of federal or state law, no fuel containing MTBE shall be deemed a defective product by virtue of the fact that it is or contains MTBE. So that's what they tried to do. Any day now we will have a result from the state of New Hampshire trial. The closing arguments in that case are tomorrow, and then it goes to the jury. But South Tahoe got nearly $70 million primarily from Shell. New York City, the Exxon case, got a $105 million verdict for one set of wells, with more sets to come someday. That's up on appeal. New Hampshire will soon have. And in other settlements around the country, water utilities have collected over $500 million in payments from the oil industry, which unfortunately, when you add it out on a per company basis, is not actually all that much. But MTBE is out of gasoline and has now been out of gasoline for 5 years. Should never have been there in the first place. Some final thoughts. I just have to remind myself what they are. So what's really going on here? What's really going on here with these accusations of bad science and abuse of the judicial process? Well, it goes back to the premise of Merchants of Doubt, the book that I mentioned before, which is that it is now the template when you have an attack on an entrenched industry or a product that means a lot of money to certain interests. You have a template that uses those attacks, that it's bad science. In its most benign form, it's uncertain science. But junk science is the term that they throw around. And that the courts, that they're in the juries and the judges are in the pockets of the trial lawyers, and that what we've done is manipulated the law and the science. And it's not true. And so scientists who get involved in controversies need to understand that the lessons from these earlier examples are that they were actually uses of good science. In fact, the only uses of good science, the only forums in which the good science had a level playing field. And beyond that, I think, I frequently struggle with experts. I wrestle with experts who are really dedicated and devoted scientists. And they believe that the court system is a nasty, dirty process, and that they don't want to be bothered. They just want to do their work and be left alone. And it can be. It's not a pretty process. It's nor is, by the way, being castigated in the press, whether or not you're in court, as some of the climate change scientists have been discovering. But Albert Einstein said that those who know have an obligation to act, and Albert Camus said that those who fail to act in the face of knowledge and evil are as much executioners as anybody. And these are important issues, and scientists, I think, need to think about two things. One is the obligation as one who knows things that are not known by others to communicate effectively their views and have them be heard, and to allow them to be aired in the appropriate public fora. And the second thing is that knowing how to testify in court, just like knowing how to talk to the press, are not things that you learn in graduate school or as an undergraduate. They're not actually things that you learn in law school either. But there are people who teach these things. And it makes a huge difference. If you are facing a situation like where your work is important to one of these kind of important and contentious issues, get the training. Get the training, whether or not you testify in court, and if you are going to be a witness in court, don't let your lawyer throw you up unprepared. Make sure you have somebody who really understands the dynamics of the court system and what you're going to face on cross-examination. All right, I'm going to stop there. Do we have a few minutes for some questions?
Yeah, I know some folks might have to run, but Vic is here, can answer some questions, and then we're going to let him grab some lunch. If people want to come back and check in from about 2 o'clock on to 3:30 or so, he'll be here just on a drop-in basis to talk with. But go ahead, if people have time for questions right now. Go ahead.
I gather from your sort of prep points for potential testimony that you want people to think for themselves, but to be informed of what they need to do, as opposed to scripting. Like, you need to say these sorts of things, because I could imagine if someone comes across as a very scripted witness, that might also seem as potentially a ding on their credibility.
Yeah, a good question. And the answer is a little bit different when you're talking about pretrial proceedings as opposed to testifying in court. In pretrial proceedings, what happens is you post. Usually the expert writes a written report. It's given to the other side, and then you sit in a deposition and get asked questions about your opinions, and they try to figure out really understanding. The real purpose of a deposition is to understand what you're going to say and what the assumptions for those opinions are. And this is an opportunity where retreating behind jargon is perfectly okay, as are very brief answers. And what I will work on with experts in preparing for a deposition is listen really carefully to what the question is, and then only answer that question. And don't, if you think that the lawyer has completely misunderstood a point and is asking you something that is just showing how completely ignorant they are, you don't explain that to them. Just answer the question.
Vic, I know we have, I see some people here from the law school, so just, I don't know if you noticed behind you, if there's a question from that angle.
Okay, let me just finish this answer.
Laura, can you turn off the PowerPoint?
Yeah,
I think
do you want to
that
just-
happened on your end, and now we can see that a little bit better.
Okay, I think John's trying to get the lights
See if we
up.
can.
Sorry, I didn't mean to interrupt you.
I don't know how to turn it off.
All right.
So the second thing is,
Who can handle this
We'll get Carol. It's like technical difficulties.
yeah. So when you get to trial, and I'm going to assume that what we're talking about is a jury trial, then the issue is really your presentation to the jury. And the direct examination should come across, that's when it's my own interest, my own expert, and I want to elicit their opinions. And that should be rehearsed, practiced, but not scripted. And the whole key here is that you want the jury to understand that this is something. We lost the phone call. You want the jury to know that this is that the expert's presentation is something that he or she has put a lot of thought into,
They'll be back.
and that the presentation is being made for the jury's benefit. So there's nothing wrong with them understanding that it's been prepared for. On the other hand, an expert who simply seems to be repeating a rote thing is not going to be very appealing. And I'll just bore you with one short story. We had in our MTBE case against Exxon for New York, our hydrogeology modeler was a fairly young guy who had done a lot of consulting for water utilities of exactly this sort, which was to assess threats over time and figure out how long it was going to be doing. And he used the best modeling tools that he had, but they had limitations, which he acknowledged in his presentation. And on cross-examination, he was pressed because under certain parameters, his model had actually crashed. But he used some of the output from those models as a basis for some of his opinions. And they made this big deal on cross-examination. So you know, your model crashed when you put these parameters in, and you didn't change the parameters, did you? And is it good practice, do you think, to use models that crash as the basis for an opinion that's going to cost Exxon, you know, hundreds of millions of dollars if the company prevails, if the city prevails in court? And he said, look, it was essentially the modeling question we talked about. He said, you use the best information you can, you use the best models that you can, and the fact that they crashed meant that in a very real sense the model was conservative compared to what we would expect in the real world. And he handled it just very beautifully. But the reason I'm telling you this story was he had a horrible cold. And he was clearly suffering up there on the stand while he was doing it. And the Exxon lawyer was just sort of relentless, very aggressive. And when I stood up to redirect, I asked him whether he had run different iterations of his model using different parameters, and he said yes he had. And I said, well, what did you call these? And I said, well, one was iteration A and the other was iteration B. And so I said, well, those sound like very original names. And it went completely past him, and he didn't acknowledge it. So after we had won the case, I want to come back to one thing about the jury and winning the case. We took the jury out to dinner a couple of weeks after the trial was over, which is not unusual for the lawyers to do. By the way, when you have a series of cases, because it's your opportunity to really get feedback. You do mock trials, you do all this stuff, but you learn more from the actual jury than you do, because they sat there for months rather than just for a day or two. And I asked them about this, about how they had viewed this witness. And they said, we loved him. He was clearly struggling under the cold. And when he missed my joke, it had really endeared him to them. And they said that. Now, I want to come back to something about legal advocacy and demeanor. What you see here when I'm doing this talk is what juries and judges see of me. I mean, this is just who I am. And our babysitter, when I was gearing up to go to New York, my wife was talking with our babysitter, and Lee said he's going to New York to be part of this trial, and Jeannie said, wait, he's going to be in the courtroom? And he said, yeah, he's the lead trial lawyer for the city of New York. She said, he's going to be arguing in front of the jury? Yes, he's the lead trial lawyer for the city of New York. And Jeannie said, but he's so nice. So we did the opening statements for the jury, and mine was they saw some of the stuff that I showed you about MTV, and it was more, it was very factual. And this is what you're going to see. This is what the evidence, and if the Exxon witnesses testify the way they testified in pretrial, this is what they're going to say. And I sat down, and the lawyer for Exxon, if the New Yorker magazine drew a cartoon caricature of an oil industry trial, it would be this guy. He's large, he's dark, he was wearing a dark suit with a white handkerchief in his vest pocket, and he's bullied. And he stood up and he said, everything the city has just told you is lies. And he pointed and he proceeded to really, I mean, he was yelling at the jury, and we were also, okay, they must have focus grouped this. You know, this seriously. I mean, when I thought my wife was there sitting there in the courtroom, and I asked her that. I said, well, what did you think about that? I thought it was really over the top. And she said, you know, maybe it's what they think juries expect from watching TV now. You know, they can't have. So when we interviewed at the end of the case, the jury came back. They gave us this verdict for $105 million, and the judge said, I want you to stay. I'm not going to let you go, jury, until you spend 15 minutes with the lawyers from each side, because there are a lot of these MTBE cases, and both sides are entitled to learn it. And they sent a note back saying, we don't want to meet with the Exxon lawyers. And she said, you have to. And they sent another note back saying, well, then we want your bailiff and your law clerk in the jury room with us when we meet with you. So they go back in, they have their 15 minutes with the Exxon team. The Exxon team comes out stony-faced and leaves. And we go in, smiles and hugs, and we talked with them for a little bit, and then we took them to this dinner a couple of weeks later, and they told us that they had been scared of the Exxon lawyers, that they thought that they were being intimidated, and that they didn't want to have anything to do with these lawyers. Well, it's interesting because now at the New Hampshire trial, at the end of evidence last week, the jurors asked to take pictures of both teams of lawyers and to have the lawyers take pictures of the jury in the jury box. Different lawyers for Exxon now. And so they may have learned their lesson. We'll see whether it does them any good. Yeah.
Can we see if you can make David cry in a nice way?
You always make it cry. He cries all the time,
Oh,
He
okay.
just doesn't like to show it.
So are you, but you're really, seriously, you're actually saying you just are intelligent, you don't have to be aggressive to get
Well,
your
my
seriously.
style. I mean, this is one of the things that you have to understand. Lawyers have different styles, and as lawyers, you have to learn to embrace the style that you have.
Yeah.
And I warn my experts when they go into depositions in a trial that I'm actually less worried about the bullies because they keep the expert on guard, and you know it's very rare that a nasty lawyer is going to bully an expert who's been prepared into anything bad. I said the ones you have to watch out for are the ones like me, who are calm and respectful, especially in the deposition, because you'll tend to let your guard down and you'll become conversational
Very
and you'll
interesting.
concede points. I say, here's how you avoid that. Never forget for an instant that no matter how nice or respectful or congenial the opposing lawyer is, his or her role is to rip your beating heart out of your chest at trial and show it to the jury. And, you know, what I can be, in deposition, I am uniformly fairly calm like this. At trial, I'll be firm. And one of the luxuries that lawyers have at trial is that if a witness is being obviously evasive, then the jury's going to pick up on that, and you can ask the judge to directly answer. For a judge to do that is very powerful.
Yeah, that's
Yes. Yeah.
I guess this is a follow-up to your spotted owl experiences, but despite it being challenging to sue government, it seems an increasingly popular thing to do with the Federal Endangered Species Act, increasingly successful too. Is that a story of government not doing its job adequately in sync with public expectations, or do you have other thoughts about where this is all leading with that law and that policy overall?
My personal views on that are sort of nuanced. On the one hand, if you look at the nonprofit world, which is what many people think of as environmental law, I don't know the exact percentage, but it's in the high 90% of the lawsuits that are filed are against the federal government. And query whether that is actually the most effective use of litigation resources. I think that there are instances, I mean, I think that our spotted owl cases were necessary and important, and I think they led to good policy changes. But there are strong incentives institutionally in the nonprofit world for bringing Endangered Species Act claims as opposed against the government as opposed to suing industry over environmental issues. And those have to do with the training and expertise of their lawyers, and have to do with the availability of attorney's fees awards when they prevail, and have to do with the risk and cost analysis by the organizations. So, I mean, my personal, one of the reasons that I left the nonprofit world was because I felt that while much of the work that was being done against the government was valuable, I wasn't sure that that was where the most important environmental work could be done. And for me personally, getting into water issues against the petrochemical, agrochemical industry struck me as more satisfying personally. But as to how they keep winning, you know, I don't know what the statistics are, but I will say that my impression is that while the government has been slow to do it right, and particularly in certain administrations has been more inclined to the thumb on the scale political interference model than in others, it becomes increasingly difficult to win significant cases against the government just because the National Environmental Policy Act is no longer new, and nor is the Endangered Species Act, and the government is learning how to do. Remember, as I say, if they follow the proper procedures and have at least one expert that agrees with them, the suits cannot be successful. So it's as much it is a tribute to continued failure to do things right, but it's also because that's where all the effort is going on the suing side. Very personal view. We lost the law school.
Yeah. So please feel free to stop back and make your Thanks, everyone.